Good morning, this is Scott Goldstein. I'm a New Jersey bankruptcy attorney and I'm the principal and founder of the law offices of Scott J. Goldstein. I represent clients in New York and New Jersey. So today what I want to talk to people about is what happens when you file for bankruptcy and you own things. This has come up on many of my cases, and the major issue is not when it comes to personal property, houses, cars, things like that, though it has occurred. What my major concern is what happens when you have a personal injury matter or other similar litigation that existed prior to the bankruptcy or the claim for which existed prior to the bankruptcy. What happens when you file for, let's start with Chapter 7, then we'll talk about Chapter 13. So in a Chapter 7 case, everything you own, including your abilities to file lawsuits, belongs to the bankruptcy estate, and it can be liquidated or sold for the benefit of your creditors. The ordinary thing that happens in Chapter 7 is that your attorney in that matter will be retained by the bankruptcy court to represent the bankruptcy estate, which now owns the claim, and they'll prosecute it just like they would otherwise. You'll normally have claimed a certain kind of exemption, which will protect a certain amount of money from that claim, and you will get that for the most part, unless you have done something like taking out a litigation loan, in which case that might affect your ability to get your exemption. What will then happen is once the case is resolved, the trustee in your case will then take whatever is not protected and distribute it out to your creditors. And whatever is left over will go to you, minus one big thing: trustee fees and commissions. The trustee is entitled to a commission of 10% of whatever is collected and distributed to creditors. So if you have a $300,000 recovery after your attorney gets his money, then you've got $30,000 is going to go to trustee commissions. In many cases, the trustee will also retain themselves or retain separate counsel to do any, as we call it, lawyery stuff in the bankruptcy court to make sure that the estate is prosecuted and these distributions are approved and that all the motions that are filed. They're going to bill you for that too, but they're not billing you specifically. They're billing the bankruptcy estate, and they will collect out of the recovery that the bankruptcy estate has. And that is simply because the trustee is not actually representing you, they are representing your bankruptcy estate. Now, in Chapter 13, you'll still have to pay in the non-exempt proceeds of whatever case it is, and that'll pay off your plan faster usually, but you get to control that and you avoid the trustee attorney's fees. So, and you will still get hit with commissions because when you make a payment into the Chapter 13 trustee, they'll take their commission out of their payouts, but you'll avoid the attorney's fees that the Chapter 7 trustee or their attorney will charge you. So, unfortunately, when you have litigation proceeds in your bankruptcy, that's going to end up mostly going to your creditors, and it will also end up with trustee commissions being deducted. Obviously, that's not going to be the entirety of it. There are your exemptions, so you will get something back. But know before you go that if you have a personal injury case, it's largely going to go to creditors and things like that. Same with employment violations or anything else like that. Any sort of litigation that you are a part of may well go to feed your creditors rather than you. I hope this clears up any questions about this issue, but please, if you have any questions or if I can help you with the matter that relates to this, contact me. My information is at the end of the clip. Thank you.